Welcome to eDiscovery Leaders Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal-Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in. Welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha. I head up brand awareness at Reveal. On each episode of eDiscovery Leaders Live, I get the chance to chat with luminaries in eDiscovery and related areas. Past episodes are available on the Reveal website. Go to revealdata.com, select resources, then select eDiscovery Leaders Live. My guest this week is Susan Bennett. Susan is founder and executive director of InfoGovANZ. Susan, welcome.
Thanks very much, George. It's great to be with you and everyone who's attending today's session.
Glad to have you here. Now, normally you would be in Australia, but that's not the case right now, is it?
Correct. I'm actually sitting here in New York following Legal Week last week and before the commencement of IAPP Global Summit in DC next week.
So I'm going to ask you about both those things, if I remember. But before we get to that, what I'd like you to do is give us a little bit about who you are, what you do, and how it is that you ended up doing what you do.
Well, I've been a lawyer now for more than 30 years. So first and foremost, I'm a lawyer. For more than 20 of those years, I did large-scale commercial litigation disputes and royal commissions and regulatory investigations, mostly in Australia, but I also did a couple of years in the UK and London as well. And it's more than 10 years ago now, I set up my own business, and I now work at the intersection of data technology and regulatory compliance, helping organisations to configure technology and their people and their policies and processes to be compliant so that they can minimise risks and costs, and also as part of the digital transformation, optimise and data and leverage technology. So I'm really trying to work across organisational silos at the very senior part of organisations with boards and senior executives and those running big project teams to implement change and transformation within those organisations in what is a very challenging environment.
You then made a big change at some point. As to the first part of your career, the first 20 years or so, I have a very specific question. For those of us in the U.S. who are not familiar with royal commissions, what are those?
So we've got this great facility in Commonwealth countries. It's really about shedding light on things that are government failures, in a sense. So we've got a Royal Commission going on at the moment in Australia into robo-debt, and that was a debt recovery program, an automated decision, a debt-generated debt collection piece of technology that was used for welfare recipients who had received what was alleged to have been overpayments. It turned out that the technology had been wrongly configured, not properly understood. So the technology did what it was supposed to do, but it didn't fit with the legislative requirements. So people received letters saying they were owed they owed the government large sums of money when in fact they didn't, because they met the requirements to receive welfare payments. So it incorrectly calculated against the requirements of the legislation which permitted them to receive those payments, but there was a discrepancy. So we've got a Royal Commission into why that happened, and it's been ongoing for some months, and the findings are going to be extremely interesting. It's made headline news. But from time to time, where we have government scandals or big problems that are revealed, like we've had the other famous Royal Commission in recent times has been a commission of inquiry into banks and the financial sector and what's corporate misconduct, and examining what the problems were and then making recommendations. So those recommendations generally, but not always, lead to legislative change. We also have them in relation to natural disasters where we've had big fires, and to understand what the cause of the fires are, what the responses are, and how we can better respond to those. So they cross a wide range of activities. And what happens in those Royal Commissions is that if you're an organisation or a government department, you'll be given many, usually, notices to produce, like subpoenas. So one of the things, I was actually a solicitor assisting in a second Royal Commission into the same thing 10 years later, where our government solicitors were conflicted out of acting. So I had an internal role, which is quite unusual. And I found more documents in the second Royal Commission than had been discovered and produced 10 years earlier in the first Royal Commission. So that's where, from doing large litigation, predating the E in e-discovery, and then the very earliest developments of technology, including Ringtail, for example, in Australia. Also having my own computer programmer on a large scale commercial dispute back in the late 1990s, where between three parties, $19 million had been expended on e-discovery, and it was still at that point 12 or 18 months away from trial, bogged down in what remains today reported e-discovery decisions on privilege, on document production, backup tapes. So that's where my roots in e-discovery came from, and this issue about the importance of record keeping, but also being able to find what you needed to produce going forward. So that's developed and evolved in more recent years into complying with GDPR requirements and rolling out, binding corporate rules in the Asia Pac area, and understanding that data and information lifecycle management is critical for organisations going forward, although it's been slow because we haven't had the same development of e-discovery and information governance in Australia as developed post Enron, Sarbanes-Oxley, Frank Dodd, and then of course the work of EDRM, Sedona, and then the federal court rules here in the US. So we didn't really have that in Australia, but what we had in Australia were commercial judges, both in the Supreme Courts, in the commercial list divisions, particularly in New South Wales and Victoria, and federal court judges who were very keen to have proportional discovery and not to have large sums of money spent by multinationals bogged down in discovery. So our judges and court decisions were very focused on proportional costs in e-discovery. So that was sort of, I was very interested in the Zuba Lake decisions when they came out in 2003 to 2005, because these were issues that we were having in cases in Australia, but we didn't have the development of the law that you had here developing in the US.
What then is InfoGovANZ, and how did you get from there to hear from what you were doing on the Royal Commissions and all of that to what you now do with InfoGovANZ?
Well, Jason Barron, I heard him speaking about information governance, and I had not heard of the concept. That was back in 2014, and it just resonated with me. It made eminent sense. And at that stage, I was doing some work on the back end of corruption inquiries, in fact, in fixing up processes and procedures in the back end of organisations to strengthen their governance so they wouldn't have issues going forward. And with my background, it seemed clear to me that this was something that every organisation needed to be doing. And I'd never heard of the concept before because, as I've just explained, we didn't have the same extent of ACEDS had emerged in the US. So after a little while and thinking about these issues and being encouraged to write on information governance, and I'd been writing on good record keeping and why it was so important since 2007, I think. And I thought, if no one else was talking about information governance in Australia, someone needed to. So we set up an organisation called InfoGovANZ with the primary aim of having a website to talk about it. And then ActiveNav came along and said, we'll sponsor you. And so then we thought we better have some launch events. So we had some launch events, and in New Zealand, our launch event was, our guest speaker was John Edwards, who was the then Privacy Commissioner for New Zealand. He's now the UK ICO Commissioner. And at our launch event in New South Wales, we had the New South Wales Information and Privacy Commissioner come along, who was very interested in this area. And so over the years, I've come to work with a number of the regulators to talk about the intersection of some of these merging areas, particularly around privacy and privacy regulation, but also I know many of your members and clients also come from the government space, and what we know in the government space is access to information, and for large corporates being able to find personal information, correct and delete it under the requirements of the GDPR are becoming really big issues for organisations.
So those are big issues. What can be done or is being done about those issues?
Well, it's very difficult because most organisations are siloed according to traditional areas. So IT, legal, compliance, your innovation hub, your procurement area, and often they're housed in different areas within the organisation within different reporting lines. So when you're looking to bring in a new piece of technology, that might be a business driver or a marketing objective, and you've got a procurement process, often the last place it ends up is with legal. And, you know, we talk about in privacy, requiring privacy by design. So that issue about having privacy involved in the initial procurement process, checking out where data is stored, which is not a big issue if you're in the US, but if you're in the EU or you're in other parts of the world, understanding where the data is stored. And obviously, you know, if you work for a government agency in a different jurisdiction, there's likely to be requirements for data to be stored within that jurisdiction. So we talk about getting privacy professionals involved early. We talk about privacy by design. Increasingly, we're focused on security by design and cybersecurity by design. But the real issue I see is this collaboration amongst the silos and the requirement of, often a big technology project will be implemented and there's, ongoing cost overruns and integration issues that don't emerge for 6 months and are still being dealt with 18 months later. And they often go under the radar, or they often come out as systemic problems several years down the track. We've had a couple of cases in Australia against 2 of our 4 largest banks on breaches of anti-money laundering legislation. We call that the AML CTF. So anti-money laundering, counter-terrorism financing legislation. And one bank was fined $700 million and the other bank was fined $1.3 billion. I refer to these as information governance failures because in one case it was simply the configuration errors in the implementation of new ATM machines where the amounts being deposited over $10,000 weren't being recorded. So just a configuration error. In the other case, the errors meant that there was non-compliance of tens of millions of transactions over a period of a number of years. And as a result, one of the more minor parts of the penalty, but in my mind an egregious breach, was the failure to keep any records as required under this particular section of the legislation for particular transactions, and we're talking about millions of them. So those fines were they're the biggest fines in Australia's corporate history. But what these really signify is these banks, like most large organisations, spend a fortune on risk and compliance. So it wasn't like those things weren't happening. It's these things weren't being picked up. So we need to have better collaboration between the organisational silos. And I say that this can be done through improved information governance mechanisms and systems as part of corporate governance within organisations.
What sort of mechanization, what sort of systems can be put in place to improve collaboration?
So one of the things we talk about is the role of the steering committee. So I'm doing a PhD, which I'm just about to submit, so everyone will be able to read it hopefully within 6 or so months. But we've always talked about the steering committee. I work with organisations that have data councils, or they'll have some sort of mechanism, but often they're not. The constituents are not always at the right level, or you might have the right people, but you're missing a couple of key areas. You may be missing people who, it may be a very senior level or committee, and that may be good, but you might be missing key areas with knowledge. So you've got to work out, I always say, you've got to fit the organisation and the structure and the mechanism according to both the maturity and both in relation to information governance and also in relation to its risk profile as well, and get a mechanism that actually will work within the organisation. What I see quite a lot of is some organisations investing very heavily in trying to put in systems and better governance, and I'll get a call 18 months after vast sums of money have been spent to say, it's not actually got the traction that it needs to get. Can you come in and help us? And it's really interesting to see what are the roadblocks. And sometimes it can be things like definitions of what is a customer. And senior executives say, what do you mean? How can this be a stumbling block that hasn't, 9 months after we agreed? How can this happen? And I go, well, if you think about it this way, this area says this other area says that, there's prospective customers, past customers, and it may be employees, what is the definition of an employee, part-time, contractor. You can get bogged down in the simplest things according to the organisation, and every organisation is unique, both in relation to its culture and its maturity and where it is given its own set of priorities and issues that it needs to deal with at any one time, both externally and internally to the organisation. So it's being able to see all of those things and then work out where you need to get to and the steps that you can do that through.
You are, as you said earlier, in the United States for a period of time. You were just at Legal Week last week. What are your takeaways from Legal Week?
Well, it was it's my first Legal Week since 2020. So 2020 I was here, and then literally 5 weeks later we all went into lockdown globally, and I wondered if things would ever come back to normal again. So it was really great this year I think there was a real air of excitement about this sort of getting back to normal. So I had intended to come last year and the conference got shifted because we still had COVID. And I did come to IAPP this time last year, but there was still this sense of COVID related issues and our first time out back at conferences last year. This really had the air of getting back to normal, everyone being delighted to be back in person. I think the big takeaway, as I wrote on my short post, I've got to do a long report yet on Legal Week, is about the AI revolution that is now underway. And that hit me last week when I was here at Legal Week. Bill Gates made that announcement last week. ChatGPT-4 came out last week. And the, dinner time conversations, John Tranch said to me one evening that he thinks that it will revolutionise the way we work by the end of the year. And I started hearing people making similar comments. And then the closing keynote was an interview with Dan Schulman, the CEO of PayPal. And he recounted a story about a dinner he'd had with an investment fund manager. And that is reflected in the open letter that's been announced today by Elon Musk and Steve Wozniak and others about the need for a pause on AI. So there's an urgent need for AI regulation, as I said in my LinkedIn post. Standards are not going to be enough. The technologists are galloping ahead. Even the technologists are surprised at the rapid evolution of these large language models that we've been seeing develop. So I saw this morning. Somebody has said that we could up to 60% of all jobs could be made redundant by the developments that are now underway as a result of these big language models. And so this is why we need to make sure that we're firmly in charge, because it looks like we're going to be overrun with AI at a very rapid rate. So that means we need government regulators, people in government who actually understand and can regulate for AI. And we also need boards and directors within organisations and senior executives within government agencies to be able to ensure that the risks around AI are properly understood when we're putting these systems in place. And robo-debt is a good example of that from the Australian perspective, because there was nothing wrong with the technology. It just didn't fit with the regulatory requirements, and as a result, it led to great to people who were issued with debts that they did not have to pay, but were hounded by debt collectors and pursued through the courts at great personal costs. And in some cases, when people are discriminated against, it can put them in a much worse position, and even suicide or misinformation, visual fakes, all of that sort of thing. It can destroy our human dignity. It can lead to mental health issues. It can lead to a deficit in society well-being. So these are some of the bigger issues that need to be properly understood, along with the extraordinary benefits that, for all of us who've had a play with ChatGPT and can see, we can ask. I think Craig Ball wrote a paper on ChatGPT making a mediocre law student on e-discovery. So those make very interesting articles to understand what it can do and how it can help us, perhaps in the medical field, for studying, for making us more efficient in work. But we need to also think about some of the risks. I think one of the most incredible things is senior executives providing confidential information to ChatGPT to write PowerPoint presentations and just not thinking. And it also being used to make more sophisticated phishing attacks. So we need to understand both the opportunities, but also manage the risks. And we're responsible for managing the risks. So as people in the legal profession, we've got an obligation and a duty to be competent. Here in the US, you've actually got a specific duty to have technology competence in many of your states. In Australia, I argue that comes within our overarching obligation to be competent as legal professionals.
So there are then broad obligations, broad opportunities, and broad challenges. Tie these back to information governance in particular.
So the thing about information and the thing to bear in mind is that one of the big risks that we face at the moment as a society is disinformation. And I think when we talk about using these big language models within our organisations like ChatGPT or Bard or whatever it is we're going to use, we want information within our organisations, data that is accurate and accessible. And from that we can extract information. And on that information, all of us, from the most junior person in the organisation to board directors, make decisions. And we need accurate information to make good decisions. And in the organisational sense, we need to make good decisions to deliver on the strategic priorities of our organisation. So if you've got a lot of rot, redundant, outdated, trivial and transitory data, you can be accessing data that's out of date. You can also have system issues. And as we have this proliferation of different types of communication systems, I long for the day that we're just using email again. I know that's perhaps a very old-fashioned thing for me to say, but not only is it generating a lot of work in e-discovery, but actually I find this myself. I've had to say to people, where did we have that conversation? And then somebody says to me, on LinkedIn, Susan. And I think, why would anyone be having a conversation about anything of substance on LinkedIn? But people communicate on every type of communication method, and it's not optimal. But for an efficient organisation, and most of our organisations run on information, for those of us in e-discovery, you're extracting relevant documents to be subject of scrutiny and testing in a legal proceeding, whether it's a court case or a regulatory investigation or a royal commission or a commission of inquiry. That's what the task of it is. But in in organisations in everyday use, you want the correct template to use. You want to be using this year's logo, not the one that you were using in December last year. All of those things matter, and you want to be able to do them as efficiently as possible. One of the issues I see with the digital transformation agenda is people find a solution to a problem, but often that technology solution requires and creates other issues, particularly around the integration with other systems. So the governance of the technology systems and the data in it is critically important. From the data perspective, personal data and personal information and where that sits within an organisation is critically important. Cross-border transfer of data, we know, is a big issue out of the EU because of the GDPR, but increasingly countries around the world are strengthening their privacy regulations, and data localization is becoming a big issue. So ensuring that you are complying with the privacy regulations of the countries with which you are extracting data in legal proceedings or for any other purpose for a business operation, you need to ensure that it's compliant with the jurisdiction in which you operate. And of course, with this global environment, data just flows. There's no visa or passport required for data. It just flows seamlessly across borders. So the obligation is squarely on the organisation transferring the data out of that jurisdiction. And when you look at the announcements about what AI can do, it's really incumbent on all of us to understand not only the benefits that technology and the AI tools can bring, but what are the safeguards and safety rails and mechanisms within organisations that we need to put round that. And as lawyers and as those of us in the legal industry, we've got professional obligations to do that.
We could clearly spend a lot more time on this topic, but we've come to the end of our half hour. So we're going to have to bring it to a close here. Susan Bennett is the founder and executive director of InfoGovANZ. In the States for a conference last week, Legal Tech, and we didn't even get a chance to talk about what's coming up next, but that will have to wait for another time. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. Susan, thank you so much for joining us this week.
Thanks for inviting me. It's been great to be with you and to be here in New York and the US.